source or the origin, and they deal with the distribution aspects in these two judgments. It may be a little extreme to suggest that material resources of the community only means resources we do not have their origin in the private property of an individual. I'll tell you why it will be dangerous to take that view. Take simple things like mines, forests, even private forests. For us to, for instance, say that, look, the moment a forest is a private forest, 39B will not apply, would be, and therefore it's hands off, would be extremely dangerous a proposition. It depends upon context, as Brother Dulia said yesterday to us when we were discussing on the bench. It depends on the context. In a given case, a private house.
Zamindari land.
Yeah, exactly. Zamindari lands. That was the whole basis of our agricultural ceiling laws.
Yes.
Whether it was the UPZA and LR Act or the Maharashtra Agricultural Ceiling on Agricultural Lands Act. So we must have regard to, we must put ourselves back in the 1950s when the Constitution was made. So the Constitution which was intended to bring about a sense of social transformation. And that was the transformative ideal of the Constitution. Whether this act is valid is a completely different issue.
Yes.
Is a completely different issue. That will ultimately be decided. But we can't say that 39B has no application once property is privately held property. Because the societal demands, the societal welfare, the need for redistribution, considering the societal perspective. So it may be airwaves, it may be water, it may be forests, it may be mines. In some areas, probably the dividing line becomes very clear. Just taking somebody's flat. Possibly, you may have a point on that. But we must understand that 39B has been crafted in a certain constitutional ethos. That the Constitution was intended to bring about a social transformation. So we shouldn't therefore go as far as to say that the moment private property is private property, that 39B and C will have no application.
So, Lordships, may I just...
The second thing which I wanted to tell you was that whether 39B and C can have two consequences in our constitutional law, right? One, the moment a law is enacted to give effect to 39B and C, that law is immune from challenge under Article 31C, unless you come to the conclusion that the law has no nexus to 39B and C, which was what was struck down in Keshwanand Bharati. The moment a law is in furtherance of 39B and C, that law has an immunity under 31C. But even if the law does not have an immunity under 31C, right? Even if the law is not immune from 31C for some reason, say some bench comes to a conclusion that 31C does not exist on the statute book today. Even so, the fact that the law has been made in pursuance of 39B and C may be an index of its reasonableness. That's not just 39B and C. The fact that Parliament or the state legislature has enacted a law to give effect to any of the directive principles is an index of its reasonableness. But reasonableness postulates that it's subject to or amenable to judicial review. What 31C did was, it completely excluded from judicial review on grounds of 14 and 19,
yes,
leaving open again now other constitutional challenges.
Right.
So I think that's where the matter really lies in that sense.
So, Lordships, I'll just...
Today, Mr. Andarjuna didn't argue on 31C. We'll ask the other side when we are on 31C, because one thing which we are thinking aloud, actually, not just for you, but for the other side when they take up their view. The argument that this law has no nexus to 39B and C, right, postulates that 31C is valid, because that whole argument that the law on your side, that the law has no nexus to 39B and C, postulates that because it has no nexus to 39B and C, therefore the law is not protected by 31C.
Yes.
Which means that 31C is there.
Exactly.
But because the law has no nexus to 39B and C, therefore this law is bad.
Yes.
Right? But if 31C does not exist at all.
Absolutely.
Right?
Yes.
Then the 39B and C argument will still apply.
But independent of 31C.
Independently,
Yes,
on the ground that the law is not immune from challenge under Article 14 and 19,
exactly.
but the law is presumed to be reasonable because it is giving effect to 39B and C. There are two different things. One is an immunity from constitutional challenge. The other is the index of the reasonableness of the law.
Absolutely.
So I'm subject to hearing the other side. Now, one last thing, Mr. Attorney, Mr. Solicitor, and Mr. Dwivedi, look at it this way. The 31C argument, the 31C argument, there are succeeding constitutional bench judgments of our court which have taken the view that 31C still continues to exist. Minerva takes it, Vaman Rao takes it, subsequent decisions have taken it, though Mr. Nariman argued in the referral order
That it's on a
this was only
concession.
on a concession.
Yes.
That this was on a concession.
Yes.
Now, therefore, that 5, the correctness of the Constitution bench implicitly holding that 31C still continues to be on the Constitution, the correctness of it, if it has to be tested, which was what Mr. Nariman argued, we'll have to go to 7. We'll have to go to 7 judges. 9, the reference to 9 came only because of Ranganath Reddy,
Yes.
Justice Krishna's judgment, which was then adopted in Sanjeev Folk. Therefore, the bench felt, let's go to 9.
Yes.
But even if we don't go into 31C, 31C will have to be decided. Whether
Yes.
31C is on the statute book will have to be decided by a bench of 7 judges.
Yes. Absolutely.
Now, the question is whether we should leave it for a future day for some 7-judge bench to decide it, or decide it here, because we are certainly a bench of 9 can certainly decide it. Why leave the law in a state of uncertainty?
Lordships, on our side,
Because
speaking
75
for
years
myself.
down the line, for this court to say that 31C does not exist
Yes.
will be a very radical constitutional consequence. So all the laws which have been protected under 31C will become vulnerable. Therefore, instead of leaving this to a future, litigation before 7 judges, you may also reflect on it that perhaps we should resolve it and put,
We're okay with it. Before that.
Request.
you may have to hear them on the 31C argument, and we'll allow you to respond to it, because, leaving things in constitutional uncertainty is also not good thing for the nation.
Reflect and respond. My immediate response is, there is no uncertainty about 31C.
We have 5 judges have held, though, according to Mr. Nariman, Mr. Pari Nariman,
Yes.
that this was on a concession.
But it is not so. But be that as it may, nobody has doubted 31C now.
It is not so. Then is it not really desirable that a bench of 9 should put an end to this controversy? Because otherwise what happens is a whole host of laws become just vulnerable to challenge. We are not concerned about the merits of this law which is in challenge before us. That's the least bit of a problem, the least bit of the worry. Whether this law is upheld or struck down does not really, in that sense, alter the nation's constitutional fabric.
Correct. My lord, what possibly, my lord, Mr. Nariman also argued, and what was the point in controversy was not whether 31C survives or not. The question was, partly 31C having been set aside, whether there would be a revival of what is already gone. That's all.
That's the point.
That's all, not the validity of 31C.
The revival. Because what happens is 31C in Keshwanand Bharti is struck down, only the last part is struck
Correct.
down.
Yes.
Which said that whether the law actually gives effect to 39B and C would not be inquired into by any court. That was
So
the latter part.
judicial review was taken away, which is settled.
Keshwanand Bharti said, no, that part is unconstitutional. Whether the law actually gives effect to 39B and C is reviewable. So Keshwanand Bharti strikes it down. Therefore, the substantive part of Article 31C is upheld by Keshwanand Bharti. Now, what Parliament did was in the 42nd Amendment, they expanded the ambit of 31C by including not merely a challenge on 14 and 19, but on all the fundamental rights.
Part 3.
Lordships, on all directive principles. Instead of
all
only
directive
39B and C.
On all directive
All
principles, right? Instead of 39B and C, they said all directive principles. That is struck down in Minerva Mills. Now, what is the consequence of the decision in Minerva? Does that only strike down the expansion of the ambit of 31C to all directive principles?
Yes.
Or does it leave intact 39B and C? Now, if your contention is the latter contention.
Yes.
39B and C, it still continues to be valid. But is it not important that we deal with that and decide it?
But the difficulty is, neither anyone has addressed, that your lordships can permit addressing. We have also not, examined from that point of view, Because according to us, and at the outset, I pointed out that the controversy before this bench is limited.
But what's going to happen is this will go back right away before 7 judges to argue that. And what we are doing is, we are dealing with the offshoot, namely 39B and C,
Yes.
without dealing with the mother, which is 31C.
But
If 31C, if they are right, for a moment, hypothesis, if they are right, that 31C does not exist on the Constitution today by virtue of the judgment in Minerva Mills, then whether the law is protected under 31C as giving effect to 39B and C does not arise at all.
correct, my lords, but nobody has doubted that proposition, which may, give rise to a re-examination by the larger bench.
The first referring order specifically raises this as Mr. Nariman's argument. In the second and third referring orders, what happened was the focus shifted to
39B.
39B and C. But the fact that Mr. Nariman, and he's observing us from heaven, the fact that Mr. Nariman raised this issue about 31C is squarely a part of a referring order. And that will have to be decided by 7 judges at the minimum.
Yes.
Five.
Decided by
It-
7.
By
can also
Five,
decide-
five, my lord.
No,
By-
it has to
7.
go before 7 because it has been decided by 5.
It is three.
By a
The
bench of
first
five.
reference is three.
No.
Minerva Mills is five.
Minerva Mills is 5.
Minerva Mills is five.
Minerva is 5. Vamanarao is 5.
This is the first question.
This very question has been referred by 5 to 7.
My sister just Nagaratna, with her permission, I'll just read out. The first question which Mr. Zal had raised yesterday was whether 31C of the Constitution survives after the judgment of this court in Minerva Mills, reported in so-and-so, striking down Section 4 of the Constitution, 42nd Amendment Act, 1976. Briefly, what they are arguing, they're not saying that they are right. They say that when a constitutional provision is substituted by a constitutional amendment, and that substituted constitutional amendment is struck down, that does not result in the revival of the original provision.
Yes.
Your answer to that would be, and I presume it, we have not heard you, is that when a constitutional provision is substituted by another constitutional provision to expand the ambit of that constitutional provision, then the striking down of the subsequent constitutional amendment on the ground that the expansion was unconstitutional.
The remaining part
Will
remains.
not affect the original. It will not be, because this was not an absolute substitution. This was an expansion of the ambit of the protection which Article 31C gave. And the original provision having been upheld in Keshwanand Bharati, surely the impact of a subsequent smaller bench of 5 cannot affect the validity of the provision in Keshwanand. That's your argument. That's the point that we have to deal with. But, honestly,
It was our argument, presuming 31C to be the subject.
Yeah, because on your argument on 39B presumes that 31C is valid. Now they are raising an issue as 31C is not valid. Myself.
No, they are raising, my lord, but the court has never, my lord.
I agree with you.
Your lordship, my lord, I can
But
say one
the
thing.
first referring order itself refers to this.
But my lord, thereafter, that is given up, my lord, by every larger benches. Your lordships, my lord, sitting in this combination,
Given up, actually.
my lord, your lordships, in, my lord, one line answer, in this combination, your lordships can take up, my lord. I am not on that technicality.
Even if the Attorney General or the Solicitor General is to say today that he is still there, again, there will be a question by somebody as was done, that it is a matter of concession. So should there not be a clarity on what is a very significant part of the Constitution?
My lord, let us, my lord, have, my lord, the
One thing, of course, the other side, as the Chief Justice has rightly said, they had not had the opportunity. In fact, the discussion which is emerging today might have taken them by a bit of a surprise. So I think that will have.
All of,
Actually, you know, what happened was yesterday,
One more thought.
you know, yesterday, Mr. Andarjuna was ready on 31C. Mr. Devarajan was to argue 39B. We tell, and Samir also, we told them that we are not going into 31C. So they
and
were
Manoj,
also-
we were,
they
and
were-
Manoj, I'll
we
just
put the cat
add.
among the pigeons yesterday, you see, so that's why they were.
Manoj, and I would add, we were ready to persuade your lordships that 31C does not arise, and we could.
Mr. Solicitor, we are more than willing, amenable to persuasion that look, 31C does not arrive.
Look,
That
it's
the argument of Mr. Nariman in referring order 1, there's no substance in it, please don't, but then we can at least say, if you're right on that, we will say that the continuation of 31C is now a concluded doctrine in our jurisprudence, so that we lay it down for the future, if you're right. That, you know, 31C, that there is no though it was raised by Mr. Nariman, and that was the basis for one of the reasons for referring it to bench, a larger bench, and referring order 1, that there is no substance in it. And then, you know, that attains finality unless somebody decides to refer.
Can we, Manoj,
for it, you know?
First part of.
One
which
thought.
can we
Hear the-
respond, Manoj, after consulting?
In which case, after we've heard your submissions on 39B, we'll hear them on 31C. Mr. Andarjuna has broadly argued it. And then we'll hear him, you know, intensively for a couple of hours and hear your response on it.
One thought process. Regardless of 31C. If 31C has not even invoked 39,
Sorry?
if 31C has not referred to 39 at all, I'm just looking at it. Now, the law is that the directive principle state policy, any action, state action taken in pursuance of state policy, are presumed to be in public interest.
But 31C refers to 39B and C.
I close my eyes to 31C for a minute.
Yes.
So 39B will still be a support, a framework of support for sustaining this law, without reference to 31C.
That I said when I was explaining it. That
That's right.
it should
Therefore-
be reasonable.
Exactly.
That I said right
So
after.
it's only,
That
all
even
these,
if the law is not protected by 31C, the fact that the law is in furtherance of 39B and C is an index of its reasonableness, isn't it?
therefore, whether the court should go into a 31C argument.
But 14 and 19 would be excluded if 31C protects the law. Then they will argue everything else, 300 and A and, you know, 21 and all, that's, then the nature of the challenge is constricted then before the regular bench.
And if I can just add, the second
Yeah,
reference
I
order also mentions the 31C issue, that is
The
5 to
court
7
can
also
avoid
mentions.
going into a 31C. I understand the reason, the reason that why the court would like to put an end to any controversy whatsoever. But I think we need to
You see, what
address the
happens
court
is
on a very
that,
larger
as
framework.
Samir is saying, the second order refers to 31C. The reference to 9 comes about only because of
Mafat
Ranganath Reddy being 7 judges.
That's right.
and
Right.
Mafat Lal.
But therefore, part of the
And
challenge
Mafat
Mafat Lal.
Mafat Lal, 9
Lal being
judges.
9.
Mafatlal.
Mafat Lal being 9. But they didn't refer it to 11 for the reason that Mafat Lal, that observation is obviously an obiter.
No, Manoj, it is not. Manoj, please don't say. That's our argument. We will persuade your lordships it is not an obiter.
Mafat are invited to get into.
But your lordships have possibly preempted our argument. And Manoj, the reasons are simple. The Attorney General argued, findings are recorded, and obiter is not dealt with by the concurring or dissenting judgment. Even the dissenting judgment deals with it.
So the attorney general must do justice to it now.
All right. Therefore, we will take your argument that, you know, Mafat Lal concludes it. Therefore, 9 will deal with 39B and C, but their argument on
31C.
31C will have to be dealt with by whom? Somebody will have to deal with it, by at least 7.
Manoj, we are before the Honorable Chief Justice, bench presided by the Honorable Chief Justice. Manoj, no technical arguments can weigh.
He'll say that, look, my argument on 31C has to be, somebody has to answer it. 5 can't answer it.
Correct.
After we decide this matter, they'll say, now refer that to 7. So after this round, again it will go back to 7.
Manoj, correct, Manoj, but thereafter,
Stop them from having their day in
Manoj,
court.
thereafter the benches, larger benches than Manoj, the one which referred, my lord, felt that it is not necessary, my lord. It's not that, my lord, without,
It's not rejected. You see, the 7 judges, while referring it to 9, didn't reject the 31C argument which they are making. They just referred to this
by
because of-
non-referring, they have rejected, my lord. My lord,
No,
they had an option of referring everything.
31C will have to deal with actually.
The reference is by implication. Cannot. Not referring to 31C over and over again.
My lord,
But the
there were 5 issues, they refer 4, meaning thereby, my lord, they have not referred the 5th.
We settle it. We'll have to deal with
Lord,
it.
your lordships can settle several issues which might even incidentally arise academically. Academically, my lord, I can raise 5 issues.
So we'll have to go.
Lord,
go
I
to
can-
Minerva Mills actually. What
Lord-
was the ground on which Minerva Mills struck down 31C? If Minerva Mills says, as I believe it does, that this expansion of 31C to include all directive principles is unconstitutional, then Minerva Mills has left the substratum of original 31C intact.
As affirmed by Keshavananda Bharati.
No, Minerva Mills is
Second,
subsequent.
and look at the consequence of other.
Correct, but Keshwanand Bharti is 13 judges, my lord.
Another thing, Mr. Solicitor, look at the consequence of, suppose we were to accept their submission, that 31C is not in the statute book today, right? All that it means is what? What is the consequence? That Parliament will have to bring about an amendment to reinstate the original 31C, which has been upheld by Keshwanand Bharti, which is what you are suggesting.
My lord, it's not that, my lord, your lordship knows, my lord, on the practical grounds, it's not.
Practical, no. We are not on the practical aspects. We are on the constitutional aspect. This does not prevent Parliament, no. Parliament can just, can revive and restore 31.
Well, let us, my lord, confer and respond,
So,
but, my
even
lord,
assuming that,
academically,
it's simply a question of the process, following it again.
my lord, the academically, my lord, we can raise 5 more grounds, my lord. Would the honorable 9 judges bench, my lord, invest time on something which is not referred? But, my lord, we'll respond, my lord, after.
It's part of the whole, both the questions. They are-
According to us, it is not, my lord. I can again persuade your lordships that 31C is not very consciously referred to the larger bench.
All right, what we will do is this. They are virtually completing their arguments on 39B. Now, Ms. Babar is arguing, one or two more counsel, 5 minutes we're giving them. After they have concluded that, you address us on, of course, their submission on 39B. And please tell us, argue on why the 31C issue does not arise before the 9-judge bench. Not on merits, not on merits.
Lord, I already did that, my lord, and your lordships were, according to me, persuaded.
You can take 10 minutes, you can argue that issue.
No, in other words, what is the consequence of the judgment in Minerva Mills
Correct.
on
No,
31?
that is not really the question, my lord, which is troubling my lord, the Chief Justice.
Because
I don't know why why there is some little reluctance.
No, relax.
The judgment.
There is no reluctance on our part, my lord. That means, my lord, few more weeks. That's the only.
Few more weeks, I mean, 2 hours on their side. and 2 hours.
That reference came 27 years ago. Now, the judgment which have come after that have clearly put that reference to rest tangentially without having taken up the question, but clearly it's been answered.
And tell us that,
The NJC judgment covers it fully.
Yes, my lord.
but then if you are right on that,
Yes,
please
then-
tell us that so that when a bench of 9 puts its finality, there is a certain degree of finality in the law, which is good for the nation. It's good for
Will,
the
my lord, I'll first address on that. But NJSC, in my note which I read yesterday, I didn't read it. My lord, I have quoted NJSC
That's
paragraph.
what we are saying, that please show us that, because then there is some degree of finality for
No,
the High
there is
Court.
no reluctance, my lord, kindly appreciate, but there is no reluctance before a larger bench, that too presided over by the Honorable Chief Justice of India. No technical plea referred, not referred, would arise, my lord, can be raised.
See, as we told even Mr. Andaruna yesterday, we stopped him we said, look, we are not going to reconsider the validity of 31C based on Coelho, because that has attained finality in Keshwanand Bharti. We want that to stand. We don't want to open up the canvas, because in constitutional matters, just needlessly opening up the canvas can cause grave constitutional uncertainty. We'll be the last to do
Whenever
that.
your constitution comes closer to 13 judges, it makes all of us nervous. We'd like to keep that as it's.
Well, 9 is not very far from 13, that's what he wants.
Absolutely. So, you know,
I
yeah,
would welcome, I would
let-
welcome reference to 30.
there's a great deal to be said in
Have to be
the
50.
sense of stability and